Hi, I'm Michael Ruger. I'm the managing partner at Greenbush Financial Group. Today we're going to be discussing how to protect assets from the nursing home or a long-term care event. Now, as financial planners, this topic seems to be coming up more frequently during our client meetings because usually our clients are doing this planning for their parents, their grandparents, a family member, and they've just had the unfortunate experience of watching them have to spend through all of their assets, have liens placed against their house in order to pay for the nursing home care, which is really, really expensive. When we talk about nursing home care, it typically costs between $10,000 to $15,000 per month. So it's very easy for people to spend through their net worth quickly before they're at that Medicaid level, then Medicaid picks up the tab from there. The reason why we're seeing these events with more frequency is everyone's living longer. They're living into their 80s and 90s, and what we do, you become more frail, you need a higher level of care, and that care is very expensive. And it can put married couples and individuals in a really tough financial situation, because if you look at a married couple and one spouse needs to go into a nursing home and it costs $10,000, $15,000 a month, they might have to spend through most of their marital assets. Meanwhile, the spouse that's still at home could live for another 10 or 15 years, but the assets are already gone. Or an individual may want to pass their assets on to the kids, but if it's all spent on their care, those assets are gone. The good news is, with some advanced planning, there are strategies that we do put in place for clients to help protect that from happening, and that's what I'm going to share with you today. Before I get into strategies, I do want to acknowledge that the elder law and Medicaid rules do vary state by state. Now, what we're going to be covering today really applies for New York State residents. However, if you're from another state, you're still going to learn a lot from this as far as strategies that could carry over to your state, but it's just important to then consult a professional within your state that knows elder law to make sure it's a good fit. When we start talking about different strategies for managing this long-term care risk, many individuals are aware of what's called long-term care insurance. So you get these insurance policies, you pay the premium throughout your lifetime, and then if there's a long-term care event down the road, these insurance policies pay out. But there have been some challenges with that solution over the past 5 to 10 years. The first one being, if you're over 70, they usually will not issue you a policy. If you're getting the policy in your 50s and your 60s, if you have any issues with your health history, a lot of times they will not issue the policy, or it'll be very, very expensive. And then the third is the cost of these policies have gone up dramatically in the last 5 or 10 years, so it becomes an affordability issue. The reason why these policies tend to be more expensive than people expect is if you have one of these policies and you're 65 or older, like at some point there's a high likelihood that this policy is going to have to pay a benefit. And like we talked about, the cost is large, so those payouts are big. The insurance companies don't like that. They like to issue insurance policies where the likelihood of a payout is low, and then they just collect your premium payments over time. When you start looking at the cost of these policies, at least in New York, for an individual that wants really a robust long-term care policy, it's not uncommon for it to cost between $4,000 and $6,000 per year for that coverage. So you have to have enough retirement assets set aside to really keep paying those premium payments for essentially the rest of your life. And it's for that reason that even though 15, 20 years ago, this used to be the solution when it was much more cost effective, now that it's become more expensive given the high frequency of the payouts, it's really become more of a luxury item. So the question becomes, if I don't go the long-term care insurance route, how do I plan to mitigate this risk? So if an individual doesn't have long-term care insurance, the next option we usually discuss is setting up a Medicaid trust. Now, setting up a Medicaid trust, you're almost setting up this legal entity that you establish to own your non-retirement assets. So things like your house, stocks, non-qualified annuities, permanent insurance policies, because you want to put it in this trust, because if it's owned by your trust for a 5-year period, and then you have a long-term care event require you go in a nursing home, Medicaid cannot look at this trust any longer as an asset subject to spend down. So that's preserved. You qualify for Medicaid. Medicaid pays for your care, but then all of your assets that are still owned by that trust are preserved for your spouse and your heirs going forward. Now, often individuals make the mistake of saying a trust, like, isn't the trust just for like the uber wealthy and the Rockefellers that have tens of millions of dollars? It's actually not the case. Trust work is becoming much more common for individuals. I mean, we've had clients that all they have is a house and they're getting Social Security and a small pension, but it still makes sense to set up this Medicaid trust because we know no matter what happens in the future that the house at least is going to go to the kids as long as we can get by that 5-year look back period. The reason why I keep referencing this kind of 5-year holding period is in New York, if someone goes into a nursing home and they're just an individual, New York requires them to spend through all of their countable assets until they reach a threshold of about $15,700 in 2020. Once you reach that asset threshold, then you can qualify for Medicaid, and Medicaid will start paying the nursing home care for there. But they don't stop there saying, hey, show us you only have $15,000. They say if you've given away any assets to an individual, to a trust, to anyone in the last 5 years, those assets are back on the table for purposes of the spend down. Because what they don't want you to do is you have a long-term care event, you give all your assets to your family, you say you have nothing, and then Medicare is on the hook for the full cost of your care. They say, no. We're going to go back and look at your bank records, everything for the last 5 years. If it's been given away, it's coming back on, and you have to get those assets back and spend them down before you're going to qualify for Medicaid. I can best illustrate this for you in an example. So let's say we have Jim, who's 88 years old, and he's got $100,000 sitting in a savings account, and his health is starting to deteriorate. So because he's starting to go downhill, he kind of gifts assets to his kids. Let's say he gives them $90,000 just to get it out of his name. And then 2 years later, Jim has a stroke. And he has to go into a nursing home. He applies for Medicaid because now he only has $10,000 left in his name, so he's under the $15,000 threshold, but Medicaid says, give us 5 years worth of bank records. They find out that 2 years ago, Jim gifted that $90,000 to his kids, and they say, nope, you don't qualify for Medicaid because you gifted that money away. You have to spend down that 90 grand before you qualify. But unfortunately, the kids have already spent it. So now Jim doesn't qualify for Medicaid. The assets aren't there to spend down for Jim's care, and it puts him in a really difficult situation. If instead Jim had set up this Medicaid trust when he was age, let's say 84. So at 84, he still has this $100,000 sitting in his savings account. He realizes he's never really going to need it to live off of. So he moves $90,000 of that into the Jim Family Trust. He gets by that 5-year look back period, and then at 90, he has a stroke, which requires him to go to a nursing home. They can't look at it as a countable asset no matter how much money's in that trust. If that trust has grown to $1 million, it doesn't matter. He would qualify for Medicaid. Medicaid would pay for his care, and all those assets in the trust would automatically go to his beneficiaries. The other advantage with this trust strategy is if you put the assets in a trust instead of gifting it directly to individuals, those assets should still be there, that if for some reason the individual did not make it past the 5-year period, that yep, the money, it didn't work, money comes back out of the trust, but at least those assets are there to pay for their care as part of the spend down. These Medicaid trusts are considered irrevocable trusts, which means when you gift assets to this trust, you are essentially giving them away and are not supposed to be able to take them back. Now, sometimes that scares people, saying, well, if I give it away and for some reason I need them back, there's going to be no way I can get to them, and it scares them out of this trust strategy. It shouldn't, because estate attorneys can build enough flexibility and language in the document that if something unforeseen happens, there are ways to get around that irrevocability of the trust. But before I get into some of the flexibility that the attorneys build into these trust agreements, I do want to find a few roles and terms within these trusts as we kind of go through this. So the first is the grantor. So the grantor of the trust is the one that is actually giving the assets to the trust or transferring assets into the trust. So if I establish a trust for myself and I move my house, stocks, and whatnot into the trust, I am the grantor. There's also a trustee. So the trustee is the individual that's responsible for managing the assets in the trust, distributing assets to the beneficiary, things like that. And an irrevocable trust like a Medicaid trust, usually the grantor and the trustee are not the same person. It is very common that if these are parents that are setting up this Medicaid trust, that they'll a lot of times designate one or more of their children as trustees of the trust. Because if you have the ability to gift money but still have full control of the trust, the question is, have you really gifted it away, or is it really still your asset? For Medicaid purposes, we want to show that we have some distance from those assets for that 5-year period. Otherwise, it could be called into question. So you have to select a trustee that you trust to kind of oversee your assets while they're in there. And then the last is the beneficiary. So the beneficiaries of the trust are the ones that ultimately receive those assets owned by the trust. In many cases, people's wills and the trust beneficiaries mimic the same. So if it's parents, a lot of times the kids are listed as beneficiaries in the will and in the trust separately. Even though by giving these assets to your trust, you're not supposed to touch the principal of those assets, the grantors still have access to any income that's generated by those trust assets. So let's just, for an example, say Mark and Sarah married, they've got a house and they've got a $200,000 investment account, and they put the house and the investment account in their trust. Now they can't touch the principal, that $200,000 of the investment account, but if that account is generating dividends and interest, they can have access to that each year and distribute that to themselves. So there's some flexibility there. One of the flexibility features that these estate attorneys can build into the trust document is giving the trustee the power to revoke a portion or all of the trust assets. So in that example with Mark and Sarah, they just funded the Medicaid Trust with their house and that $200,000 investment account. Then 2 years later, Sarah has a health event and they get a $50,000 medical bill that they need money to pay. The trustees, which may be their kids, can just revoke $50,000 of that investment account out of the trust, give it back to Mark and Sarah. Meanwhile, the house and the $150 that's still in that investment account will still be counting towards that 5-year clock. So that ability to revoke is one of those flexibility items they can put in there. Another feature that attorneys can build in these documents to give some flexibility is giving the trustees the power to gift trust assets to the beneficiaries while the grantors are still alive. So what that does in that example we just looked at, where Sarah incurs that $50,000 medical bills 2 years after funding the trust, now instead of having to revoke part of the trust, the beneficiaries of the trust, which are their kids, can just gift themselves $50,000, and then they turn around and gift it back to Mark and Sarah, their parents, so they can pay their medical bills. But just kind of know that by adding in this gifting feature to the trust document, you really have to trust your trustees, because you cannot require the beneficiaries to gift the money back to the grantors. If they're making gifts, they can make gifts to themselves without returning it to the parents of the grantors. Now let's talk about putting the house in a trust. So many individuals incorrectly assume that because all I have is a house, there's no point in establishing a trust because I don't have investment accounts and all this other stuff. That's incorrect. Even though having a primary residence will not prevent you from qualifying for Medicaid, and they can't require you to sell it while you or your spouse is still alive, regardless of whether you're in a nursing home or not, Medicaid can put a lien against your house and your estate for the amount that they're paying out for your care. So if my house is worth $250,000, I go into a nursing home and Medicaid's paying $10,000 per month, and over the years they've paid out, let's say $260,000. You know, when I pass away, Medicaid may have a $260,000 lien against my estate. My house is no longer going to my kids. Medicaid is waiting for me to pass. They're going to force me to sell the house, and that's where they're going to recoup the assets. Where if I had just put the house in the trust 5 years ago, they wouldn't have been able to touch it and it would have gone to my children. The other item that can sometimes scare people away from setting up these Medicare trusts is the cost of setting them up. You do need to engage with an estate attorney. Now, it's not uncommon for these trust setup costs to range from anywhere from maybe $3,000 to $8,000 depending on who you're working with. And while that cost seems large, it has to be put in perspective. Like that example I just gave you, if my house is worth $250,000 and I'm using this trust that I paid $5,000 to set up to protect a $250,000 asset, it's probably worth just paying the $5,000. And then people will say, well, what if I don't make it past the 5 years and I paid this estate attorney $5,000 to set up this trust? Well, the reality is if you didn't make it past the 5 years, they're going to force you to spend down your assets anyways. So that $5,000 that you paid the estate attorney might have gone to the nursing home anyways. So you're not any further behind or ahead than you were before. I've mentioned a few times in this video the term countable asset, that Medicaid requires you to spend down all of your countable assets until you reach that Medicaid threshold, and then they pick up the tab. There are a number of assets that are not countable, that do not count towards that roughly $15,750 threshold for 2020. Some of them are pre-tax retirement accounts like traditional IRAs, 401ks, your house is not a countable asset, your primary residence, even though that lien problems comes into play where they can lien your estate and essentially take it after you've passed away in the form of a lien. And then third is there's a dollar threshold for prepaid funeral expenses that are not subject to spend down. But most other assets outside of that very short list are going to be subject to spend down. I do want to talk a little bit about retirement accounts because even though pre-tax retirement accounts are not considered countable assets, meaning they don't make you spend them all down before you qualify for Medicaid, they do require you to turn on required minimum distributions, which means a piece of that retirement account every year has to come out and then go towards the cost of your care. But I keep saying pre-tax because if you have Roth IRAs, those are actually countable assets. Even though they're a retirement account, they can make you spend down those Roth IRA balances as part of your total asset threshold. So if I have $100,000 in a Roth IRA, they're going to make me spend that down until my total asset threshold is around that $15,750 threshold in 2020 for Medicaid. Now let's talk about pensions and Social Security. So while these Medicaid trusts can be set up to protect assets, there's no way for us to protect income in these long-term care situations where we're trying to spend down to qualify for Medicaid. Now, Medicaid in New York has thresholds for assets, and they also have thresholds for income that say if you need to qualify for Medicaid because you're in a nursing home, we're only going to allow you to keep X amount of income each month. And for an individual in 2020 in New York, the income threshold per month is $875. That's all you're allowed to keep. So if you have pensions and Social Security above that amount, they will basically take that amount, put it towards your care, and then that individual in the nursing home is only allowed to keep $875. If you are married and it's your spouse that has to go into the nursing home, you are considered the community spouse. So as the community spouse in 2020, you are allowed to keep up to $3,216 in combined income monthly if your spouse needs to qualify for Medicaid because of the nursing home. So if you are making both Social Securities, pensions, other income that let's say it's $6,000 per month, most of that income is going to have to go towards the care until you get to that $3,216. That's what you're allowed to keep each month to meet your continued expenses. As the community spouse, you also have your own asset threshold for purposes of Medicaid. So remember I mentioned for an individual, it's $15,000. But if you're the community spouse and your spouse is in a nursing home, they get their $15,000 of assets in their name, but you as a community spouse are allowed to keep in your name the greater of $74,000 or half of the combined assets up to about $128,000. And that's the limits for 2020, and they vary from year to year. So before you run and just kind of give all your assets to these Medicaid trusts, I do want to go over a few important considerations. So the first is when you give assets to this trust, you really want to give assets that you don't think you're ever going to need to supplement your income. Like a house is easy because if you're going to live in your house forever, or even if you plan on selling your house and going somewhere else, that real estate can stay within the trust without ever leaving it. But that's not anything you're going to ever have to spend. Or if you're giving cash, you might say, I don't think I'm ever going to need to access this account to supplement my income. That might be worth putting in the trust. But you don't want to put everything in the trust and then have nothing to supplement your income if you need it down the road. The other consideration that can help with the trust is if you gift a house directly to your kids instead of using the trust, they actually inherit your cost basis, which means if you bought your house for $30,000 30 years ago and now it's worth $200,000, when you pass and they inherit it, they have to pay tax on that full gain of the house. Versus if you put that house in your Medicaid trust and the estate attorney puts the correct language in there, they would get a step up in basis when you pass, which means their cost basis is now $200,000. They can sell that house without having to pay any tax once they inherit it, which is huge. The other thing, as we've talked about, you got to do this in advance because this Medicaid trust planning only works if those trust assets have really been in there for the full 5-year period. Now, if you make it 4 years, then it might be, well, we got to pay for a year privately, but after that, we've at least protected the rest. So it's not an all or none, but you want to try and get assets in the trust as soon as possible to get by that 5-year clock. If you're a resident of New York or you're doing this work for a family member that's a resident of New York, we would be more than happy to answer any questions you have and kind of determine whether or not this Medicaid trust strategy or a different strategy might make sense for you. We can also put you in touch with great estate attorneys that can assist you with setting up these Medicaid trusts if that's the right financial decision based on your situation. Just an additional disclosure, I'm not an attorney, I'm not an accountant. This is really for educational purposes, and if you're in a different state besides New York, you should really consult with an elder law professional that knows the laws in your state. Thank you very much for your time, everyone.